Welcome to the Practice Masterclass presented by Magentis. This episode will cover key legal and documentation tips for medical practices. Today we're joined by Hillhouse Legal Partners Managing Director Zac Herps, who has more than 20 years' experience in litigation and business law. Zac is a renowned expert in medical and allied health, regularly presenting at conferences and events and contributing his expertise to industry publications. Today, Zac will be providing insight on how to select the right consultant for your business, IP and privacy, and estate planning and protection. I'll now hand over to Zac.
Hi everyone, my name's Zac. I am the Managing Director of Hillhouse Legal Partners. There's a few things I wanted to cover off before we get into today's presentation, and that was firstly to thank Magentis for putting this all together. The amount of resource and time and effort that goes into such things is not lost on us, and for inviting us along, we really appreciate it. And also same to you, the audience. We act for thousands of doctors, specialists, allied across all modalities, and we appreciate how incredibly time poor you are, and investing a little bit with us is not lost on us, and we really appreciate your time. We're trying to cover off and make this sort of an all things to all people, which isn't easy, so we might go through some of the material a little bit swifter than we would like to, but you'll notice as I click through the slides, there's a QR code, and you can contact us, you can contact my firm. If anyone has any questions or queries, we're here to help. That's what we're here for. Please reach out and get in touch so we can help you. The first thing I wanted to do is to talk a little bit about getting the right team around you. Just like in medicine, you'd have a team of people to help. The same should go for your corporate and business operations, I suppose. You don't have to do it all alone. We would recommend that you don't. Many accountants, lawyers, practice management companies, etc., have helped hundreds of people, thousands of people set up, structure, get tax outcomes and so forth. And you shouldn't try to do it all alone. You should lean on their expertise, not sort of figure it out by yourself as you go. We love to have joint meetings as well with various specialists in their field. So for example, if your chosen accounting firm has some thoughts on what structure your business should take or should evolve into, remembering nothing's set and forget. What may be appropriate when you're an ABN sole trader beginning might not be where you find yourself in a group of 15 people in 15 years' time. So seeking those advices, making sure that it's right for where you're at the moment is really important, and we can't stress enough getting good people around you to help you make those decisions. Another major decision for all businesses, again, be it ABN sole trader or the largest group in Victoria of insert, is what is that going to look like? Breaking it down into its, I suppose, three easiest portions is a solo practice. So that's quite common. Somebody has rooms, they have their own staff, own reception, own facility, and they're an ABN sole trader operating on their own. They're accountable to themselves. There's pros and cons of all of these structures. There isn't a right structure for every single person, and this is how it has to be done. Some people love that autonomy and control. Others would much rather pool together thoughts, resources, etc. So that wouldn't work for them. A number of the structures have similar features though. So you can see up there on the slide is, you have to choose your trading entity. That's often driven by tax and asset protection decisions. So again, seeking that expert advice from those areas and then choosing what that will look like. Obviously location, where do you want to be, where do you want to operate out of, for example, what's close to rooms and to the relevant hospital or hospitals, where is maybe competition slightly less. If you go and open up rooms, for example, in Brisbane on the terrace, and there's 25 other ophthalmologists in the same building, that could be good to group together, or you could want to try and find somewhere where there's less concentration risk. The next major one, so that's sort of solo, doing it yourself for yourself, is establishing a group. I'll speak from legal. We used to have, for example, many lawyers were in cottages and houses in every suburb all over the place, and they would have their own receptionists, their own staff, their own premises, their own consumables and so on. Medicine's been a lot the same, but you'll find that mode of operating as a law firm has diminished because the costs are too high. Having numerous paralegals, receptionists, premises to yourself is becoming so costly it's eroding margin. Medicine has a very large margin, so it was able to withhold that, but nonetheless it's starting to make more and more sense to pool together and share the costs of those assets. So for example, 10 people sharing one receptionist or two, sharing X other staff members, consumables, sharing rent, buying equipment but sharing that equipment and so on. So of course it's starting to make sense, but once you're playing in a group, you then need to play nicely with the other people in the group, and I'll come soon to some key documentation that governs your relationships with each other, because you're not just accountable to yourself like you are in the solo one I mentioned earlier. But that's establishing a group, banding together for synergy and cost saving in particular, and also you might be able to broaden your service offering with other experts that can do different things. Third option is buying into established group. So there's already an established group there. An associate may be departing or someone may be retiring, and there's an opportunity has arisen and you can enter into that. It's different again because the work of establishing a group is already done. It will normally have a hard site already, be it lease, license, or they've bought rooms and are renting them back to themselves. It will have service arrangements, staff, etc., and you'll be purchasing into that. You have to then work out if that agreement and the terms that are being offered, including if there's any consideration to pay, is appropriate for you and what you're thinking. They'll also be far more reluctant to want to change things to suit one incoming person. It'll be, well, if it's functioning well for another 5 people, we're not going to alter it very much. It can often be a take it or leave it, versus if you're establishing it yourself, you can have some say and choices in that. So once you've sort of elected, I suppose, on what the structure needs to be now or for growth in the future, that's actually another important thing just to touch on. What's right for you today doesn't necessarily mean that's where you see yourself later. So planning ahead as well. Do you see yourself in a large group with a private equity buyout of some description, or do you see yourself as, no, I want to run my own race, treating patients, practicing medicine in any way I see fit without any oversight or control from an external force like an investor or PE? Your structure might be very different. Because if you're together as a group, you need to govern your relationship with each other. There's a few key documents to make that happen. One of which is a shareholders or unit holders agreement. They're effectively the same document with a different label subject to the structure. A shareholders agreement is the shareholders within the business decide decision-making criteria and thresholds and so on for making decisions to run the business. If you're an ABN sole trader, you're not going to argue with yourself. You're just going to make the decision to either buy that piece of equipment, spend that money, disperse that profit. There's no discussion to be had. But as soon as there's 2 or more partners, you want to make sure from the get-go that you're aligned on who's contributing what to the business, what profit you're prepared to retain, for example, if necessary, what you might draw out. Decision making, if you're going to borrow money, do you all have to agree to that, or is it a 75% majority or a 50% majority? Do you want to loaning money into the practice if you decide to buy rooms? Do you all get a say in that? Do you all get an opportunity to own, or is it only maybe the senior partners who get an opportunity to own rooms? There's no right or wrong answer, but it's just making sure that it's all clear and everyone's on the same page. If you leave it as a handshake arrangement and then diverge on that, unfortunately, as the lawyers, that's where we see disputes happen over patient records and data, someone wanting to leave, disputes over money, and nobody foresaw them going, we've been friends since medical school, a handshake, we thought it would be fine, and of course it's fine until it's not fine. The ultimate is putting a shareholders agreement in a drawer for 25 years and never having to refer to it, and it's still done its job. But the worst is if you have one and it details how somebody exits, it stops disputes in the first place. There's a clear mechanism of value, what happens, who has what, and on you go. If you don't have one, that's where unfortunately you'll see people talking to litigators for many months while they fight each other, and that is incredibly time consuming, stressful and expensive, and that's why you want to avoid it. A common little saying we have inside the business is every dollar you spend on the front end will save you 100 on the back end in a dispute. So we definitely recommend setting up and agreeing on the front, and if you're not aligned to begin with, it's not the sort of people you want to go into business with. It says up there on the slide a few things about key clauses, but I've touched on most of them. Profit sharing, insurance. So what happens if something happens to you and your spouse is not let's say a specialist surgeon, they can't come in and fulfill your role. How do you value the business? How do you extract that equity and let people just carry on? How do you value it, and so on? The tips and tricks there, definitely joint meetings with accountants. We love to meet with them, get everyone on the same page and say the accounting firm is responsible for establishing ABC, the law firm will do DEF, there's no doubling up, there's no confusion, there's not competing advices from two different experts. You're all on the same page and you get on with it and get it done for the busy doctors that don't have the time to continually revisit. Another very common agreement, it's been sort of the flavour of the month for the last 18 months, is service agreements. Payroll tax is the big buzzword across Australia. They've been trying to bandy together various medical experts for payroll tax purposes to say that they're taxable wages, and so there's another tax on the business. The way that service agreement is established and then running in accordance with it, because that's the second part. We see many practices that go to the effort of documenting it, but then for efficacy or otherwise start to operate not in accordance with the agreement, and may well say banking is going to flow in X direction, or we're going to do your billing or do this or do that, and then they go, oh, the doctors haven't done billing for 3 weeks, so we'll do it for you and we'll collect the money and then we'll disperse it, and so it's not following the agreement itself. But the key things are who's responsible for what, how much is the service fee as a percentage, and what do you get for that fee you're paying in. And so long as there's clarity on that, we find that groups function really harmoniously and well, but it's when there's a disconnect where somebody thought they were going to get more than they have or pay less than they are, that then again that disgruntlement builds. You see exits, they're timely and costly, so you want clarity around those things to avoid that arising in the first place. Another key, that almost all practices will employ people, non-medical. There may be nursing and clinical as well, but reception, admin, billing, etc. The employment landscape in Australia, it's no secret, it's incredibly pro-employee. If you have to manage someone or deal with some difficult situations, it's tough, even if you have all the fair work statements and all the employment agreements and all the awards in order. If you don't, the reality is you're sort of on a hiding to nothing. Exiting a troublesome employee or practice manager or otherwise will be almost impossible. It'll take a very long time, be very stressful, and often ends up with the practice owners cutting a cheque, because that's the quicker and cheaper way to move someone on than it is to actually work through it. So again, roles, responsibilities, pay, etc., very important. The way Hillhouse put them together is in sort of a schedule form, so you don't have to come to us every single time for every single staff member, because that's not efficient. And you can change position descriptions, award rates and pay and things in the back, and leave the bulky sort of T's and C's at the front, and leave entitlements and termination periods all the same in the front. And we find that's pretty user-friendly for the group, and lets them bring on people and exit people as and when required. But couldn't recommend it enough. Very, very important, and that landscape changes frequently. So just because you had a lawyer do an employment agreement 10 years ago doesn't necessarily mean it's compliant and fine today either. So they're definitely something that's sort of, a living document that warrants review. It's not a set and forget. Lease agreement for leases and incentive deeds. Behind staff and maybe in medicine equipment, maybe, depends. Your lease or license or so on will be one of your biggest expenses. So getting that right is really important. If you commit to the wrong site where you can't expand into or can't shrink down, you can't fit it out in an appropriate fashion, you're paying far too much overs on rent. You can be trapped in that for 3, 5, 10 years, and that's a very heavy cost to bear if it's not the right place or if it doesn't align with your growth plans or otherwise. So getting someone to help you negotiate some of those terms is really important. Also incentive payments. Medical fit-outs are not cheap. When you add equipment into that as well, it can be a very heavy expense, but a lot of landlords, medical tenants are extraordinarily valued. You guys earn good money, you pay your rent, your blue chip tenants in a lot of medical precincts, they want you there, and you do have some negotiating power, and they will often contribute incentive payments and things to help you with your fit out. But again, if you're going to negotiate one for the first time our recommendation would be to go and speak to a tenant advocate or rep who's negotiated hundreds of them, knows what the market rent is. Make sure, we often see sometimes there can be a price and a doctor price. It's very unfair, but if I was to do a commercial fit out, it would be X dollars a metre, and then as soon as a medico comes in, it's Y dollars a metre, which is a lot higher than the X dollar a metre, because they assume you're all very wealthy and have the pockets to pay for it. So you want someone going into bat on your side against the landlord to make sure that you get a good deal for yourself. It has things in there, of course, the rent amount, who will contribute what to the fit out, guarantees, they'll often want to put in there a personal guarantee, for example, but you might not want that. Of course, it puts security and potentially your home and everything at risk to cover that rent, whereas a bank guarantee or a watered down guarantee position is often negotiable in a lot of buildings. But if you don't know that and you just sign it, then you're giving one, and that's an issue. Options to renew: if you build a reputation, it's close to the hospital that you want to be at, or convenient even for kids' schooling, etc. You want to make sure that if you build up that presence, after 3 years you can't be forced to move, or the rent can be doubled because you don't have a deal. You might want to have 5 by 5 by 5, so you've got plenty of time to be there if that's what suits you. Definitely negotiating a term sheet is another issue, and we recommend getting your lawyers to cast over it. A lot of agents will say they're non-binding, don't worry about it, just scribble on it and we can always talk about it afterwards. But then when the lease is produced, it's in accordance with that term sheet, and retreating from anything in that position becomes very difficult. So we would recommend having a lawyer help you there, and a tenant rep potentially, which isn't us, by the way. It's not work for Hillhouse or another law firm. There's nothing in it for us, but we think you'd get a better outcome. Even myself as a lawyer, when we went to the market, I used a tenant rep myself looking for space for us. They're just experts in that area, and you should lean on that. Another common area, I suppose, that touches almost all practices, be it establishing, growing, etc., is IP. So service entities themselves have a value. Corporates or people buying in, or associates coming on, some of the value can be in, let's call it Brisbane ophthalmologists, PTY. It pays service fees, it generates a profit, so you want to protect it. You want to protect any trademark or device or branding that it has. You don't want someone to open up 2 doors down calling themselves the same thing, people searching on Google trying to find you, and someone's passing off as yourself as potential. That market's getting a lot more competitive, and if you've carved out a great brand name for yourself and a quality reputation, you want to protect that, not have someone else cash in on it. Data and privacy is another big one. The online collection of patient forms and data, where are things stored, who can access them and when, etc., etc. There's just policy work and privacy statements and things to be had now. It's not, not every patient just walks in and fills out the manual form and you chuck it in a file like it used to be. The world has moved forward a bit for a lot of businesses, and if that data goes to the wrong place or goes offshore or does certain things, you can get yourself into trouble, even though it's not even you, it was your IT company, for example, that was in charge of that. Redundancies as well. When a server goes down somewhere in medical world, it can't then just kick automatically to the Philippines as a backup, for example. It needs to stay within Australia to protect those records. Otherwise, again, the practice owner's doing something that they may find themselves in a bit of trouble for. So we definitely recommend having your IP and trademarks and policies and procedures looked at. Another area we just wanted to touch on, again, this isn't about the practice per se, but it's more to do with each individual person within it. Almost all of you have, studied, educated for a prolonged period of time, and then the vast majority, again, are earning great money. They're trying to build up an asset base for themselves and their family. They have things outside of the business, but medical's high risk. Medical people do get sued, they get themselves into trouble, etc. And so you want to make sure that those assets and that hard work is protected for your legacy for later. It's something that's often neglected. People get they're so clinically focused, so treatment focused and business focused, that the private piece sort of comes last. I was guilty of that myself. It took me having my first child before I cleaned up my insurance and asset protection estate planning position, and I had the benefit of only having to sing down the hallway to get someone to do it for me, and I still didn't get around to it because it wasn't a priority. So I really can relate that it isn't, but it should be. The practice can form part of your estate as well. So again, if something happens to you, it also might not. It depends what structure it's held in and what happens, but it can be very challenging because often the spouse of the person may not be the exact same specialist with the same interest doing the same thing. So they can't just come in and step into one's shoes, so to speak. So then it's, have you insured against that event, and is there an insurance payment goes to a spouse if someone passes away, and then the other business owners can continue with the practice and do what they will, or is it a valuation that needs to happen, and so on. So definitely talking to a financial planner about the business insurance, loan positions, etc., and then talking to your lawyers about your asset protection and estate planning to make sure your future and your legacy and your family is taken care of. We have seen awful circumstances where people have spent a lot of money on insurances but don't have a will, and then the public trustee has withheld or retained that insurance money whilst a very lengthy legal process ensues to see where it actually should flow. And that wasn't in anybody's best interest, including the poor children. And in this case, it was the mother who was a stay-at-home mum. Husband was doing X, was killed on site, and they couldn't get access to the large insurance money for over 18 months because he died without a will, even though that was always the intention. And it eventually got there, but it cost them a lot of stress, time, and grief when you're already dealing with a horrendous situation that's avoidable by documenting it up. I've mentioned a will. Testamentary trusts are a particular document that sits inside a will. You create a trust inside so that assets can flow through that in a trust environment. We're not financial advisors, and giving financial advice is way beyond the scope of this, but there can be taxation and other benefits to that. If anyone would like to talk about those, please do. We see it's very, very common structure now for a lot of doctors to have testamentary trust wills with assets and income flowing through them. It's a far advantageous tax position than just leaving things to certain people who then have to deal with the tax consequences of that. Binding nominations are for your super fund, and where it may flow, you can nominate it goes directly to someone instead of forming part of your estate or being subject to challenge. We recommend that in numerous circumstances, but again, you need independent advice. And enduring powers of attorney and health directives have to do with capacity, and if someone loses some capacity or otherwise, and when decisions are made, health or financial or both, about you or somebody you love. So really prudent thing to do. And we highly recommend. Now guys, I know that was a little bit of a whirlwind, but thank you very much for staying the course and listening. I hope you got something out of it. Up on the screen there's a QR code. Please feel free to reach out if you've got any questions. We have information sheets on practice establishment, on growth, on asset protection, estate planning, property and so forth. We'd love to give you some more information. Thanks very much.